If you're going to file motions, you have to cite to the RCW that's applicable.
But I researched it online. It said I had 90 days.
I don't see anything in there about 90 days.
So Rule 4C?
I'm not sure what you're looking at, but CR 4C does not say that.
It's that thing. I just used the, the chat thing to go do some research for me.
Most lawyers experience ChatGPT rarely gets things right.
This wannabe lawyer, pro se plaintiff, didn't get what he wanted out of a small claim, so he moved to vacate that judgment with an 86-page filing in Superior Court, and then tries to procedurally kneecap the defense before discovery can begin, all while completely bungling service of the lawsuit on one of the defendants. He came primed to plead his motions, but his motions are clearly not ready for prime time. Thing is, ChatGPT will bullshit you just because it's Tuesday, and unless you're actually a lawyer, you won't know whether or not it's Tuesday until it's too late. Let's boners.
Ronald Brecky versus Sheila Sessions and Robert Speck. First, I'll have Mr. Brecky identify yourself from the record. For the record?
Yeah, Mr. Brecky here for the record.
Come on up. And I believe I have someone, it might be Mr. Specht here in the courtroom.
Yes.
And I'll have Mr. Specht, I'll have you identify yourself for the record.
Could you repeat that?
Can you identify yourself for the record, state your name for the record?
Yeah, things have been filed.
What's your name?
Oh, Robert Specht.
Thank you. We're going to give you an audio hearing device.
Okay, thank you.
Mr. Specht, can you hear me better now?
Yeah, I'm going to turn it down a little bit.
Okay. All right, Mr. Specht, do you anticipate Sheila Sessions joining us today?
I what?
Is Sheila joining us today?
No, Sheila has not been served yet.
Okay. All right. So, Mr. Brecky, it's your motion. I've reviewed your filings. What would you like to tell me, sir?
Well, his affirmative defenses, a number of them fail as a matter of law, and the other ones are not factually supported. It's kind of a narrative where he's just trying to influence the judge with characterizations and whatnot. And, some of them are just really, they belong in the denial category. They're not really affirmative defenses. Like the agency thing and the a good faith and even the latches, and those aren't really affirmative defenses. He's got a failure to state a claim. That's not really affirmative defense. That should be a motion, and he hasn't done that. So,
that's an affirmative defense, sir. That can be an affirmative defense. So, what specific defenses are you? Here's the problem. I read your motion and I read your amended complaint, sir.
Sure.
In your amended complaint, quite frankly, for every accusation that you're making about his affirmative defenses being inapplicable or overbroad, I have to warn you, sir, I'm not taking action on your complaint today because I wasn't asked to, but your complaint, quite frankly, suffers and your motion from the exact same problem.
You're saying it's overbroad?
Well, I'm not telling you anything other than if your chief complaint in your motion before me today is that he's putting in a lot of stuff that may or may not be relevant, I think that is a two-way street, sir, from what I reviewed.
Well, okay, for instance, he's got res judicata and claim provisions. Well, that stems from the small claims case where I just brought the matter forward for limited scope of reimbursement for temporary housing. We didn't litigate the merits of the entire claim with all the other issues that are involved, like unjust enrichment and, there's promissory estoppel, there's conspiracy between him and the daughter, there's fraud, there's a number of other issues that take a little more detail and stuff to go into. So he's trying to claim res judicata. That fails for no factual support. That wasn't litigated in small claims.
Well, how can you know what fails for factual support or not when it's merely a notice pleading answer?
Well, if he's gonna claim res judicata, he's the one who's got to bring some kind of support. He doesn't have it. He's saying the merits were litigated in small claims. They weren't.
Well, isn't that the purpose of discovery? Why would I strike that now before there's been any discovery that's occurred. I'm not suggesting he can prevail on his affirmative defenses. I'm suggesting that I'm having a difficult time foreseeing striking them when no discovery has occurred.
Okay, well, I just thought that it would be important to clear the air on that because up front, he hasn't really said anything forward. He hasn't done any declarations, anything. He hasn't sworn to anything. I mean, it's a bare bones assertion. Is that all he needs?
As most complaints, and this is a notice pleading state, as most complaints and answers are.
All right, well, what about the other ones as far as agency and good faith? I mean, those are really denials there. He's denying agency, so that's not really an affirmative defense, is it? He's claiming statute of limitations. That's not proven by the record. The record proves otherwise.
Well, you may prevail on that, sir, but I'm failing to see why I should strike affirmative defenses in this case.
Well, I'm just saying that the record already shows I filed in time. I mean, is there a statute of limitations issue that needs to be litigated or I'm okay with that if that's what you're saying, but I just thought, well, that's pretty much cut and dry. I filed in time and if he's arguing I didn't serve him the original complaint and I served him only the First Amendment complaint, well, then he's just mistaken on how that works.
Okay. What else would you like me to know?
Well, I mean, that's all I need on that count, unless you want to go on to the other motion or let Spec speak or whatever.
Yeah, you can go on to the other motion and then I'll hear from the opposing party.
Well, I had a small claims case and I tried to get a motion to vacate, and that was on October 31st. And then I did my First Amendment complaint. I filed the process server tried to serve Sheila Sessions, and he filed the non-service document. He provided me, and I filed it. We tried 3 times, and I filed an amended motion or a supplemental motion where I showed that, look, her car's gone from the driveway, and she's got a camera. She knows Spec has been served. They live a mile apart. They talk all the time, so she's really got constructive notice. So either I'd like to have an extension. And if I can't get it professionally served with X amount of tries that you set forward, then I'd like to be able to just post something on her door or whatever works, because she's really getting way more than the 20 days to respond because they obviously talk to each other. So she knows what's going on. She probably helps Spec prepare his defense and all that. She was a paralegal before, so.
I don't know anything about what 20 days to respond.
I think they have 20 days to respond when they get served, right? By the statute.
Not necessarily. I'll get to you in a minute. So where is your other motion? Where I'm not seeing it, sir. What motion? You want a motion for what?
Motion for extension of time to serve defendant Sessions.
Well, I'm confused. I don't. Why am I granting a motion to extend time? I mean, is there a statute of limitation? I just thought you said there's no statute of limitations issue.
Spec, he's claiming that there was a statute of limitations issue, but that's not true. I served him within the 90 days, I believe, by statute that you get to serve somebody. And
what statute are you referring to, sir?
I don't have the exact number in my head, but I researched it online. It said I had 90 days, so I went by that. If there's no such statute, I'll just get the process server back on it and get her served.
I don't know. This is the problem. I read your motion. I didn't see any. Here's the problem, sir. If you're going to file motions, you have to cite to the RCW that's applicable. So you're telling me you found some RCW that says there's 90 days to serve. Maybe that's true. I don't know if it is, but what I do know is that RCW is not cited in your motion for an extension of time to serve the defendant. So I don't know. Candidly, I don't know what you're referring to, sir.
Let me see if I can find it real quick here. It says 4.28.080.
You're saying there's what subsection are you looking at?
I don't see the 90 days in here, but I'm looking at 4.28.080, service of summons.
Correct. I understand that statute. I don't see anything in there about 90 days. So I'm going to.
I got Civil Rule 4C, when commenced, 90 days from the date of filing, it says to serve the complaint.
What subsection of the rule are you looking at?
I've got CR4C. For purposes of tolling any statute of limitations, an action shall be deemed commenced when the complaint's filed. If the service has not been had on the defendant prior to the
Sir,
filing, of the complaint,
I'm looking at Washington State CR4 right now. I'm not sure what you're looking at, but CR4C does not say that. If you're looking at 4D, it talks about 90 days within the date of mailing. Is that what you're referring to? The defendant must appear within 90 days of the date of mailing?
if service has not been had on the defendant prior to the filing of the complaint, the plaintiff shall cause one or more defendants to be served within 90 days from the date of the filing of the complaint.
I don't know what you're looking at, sir. And I can't figure it out for you. I can't give you legal advice. So when was this complaint filed?
It was filed September 16th. That was the 3 years from the time the first incident happened, or there was a contested eviction. I don't know. When I'm doing my research, I'm getting the 4C, but you're saying there's no 4C?
I am saying there's a 4C. I'm saying it does not say what you say it says. So this is the problem, sir, when you don't photocopy whatever you're looking at or quote it in your motion. It's just not there, sir. So I can't figure out why the difference is between what you're looking at and what I'm looking at. I have no idea if you're right or wrong. All I'm suggesting is that I am looking at Rule 4C on my computer, CR4, subsection C, and it does not say anything about 90 days. But again, none of this is in your motion. So, I don't know, whether or not you put it out for service with a process server or not. But I don't know what to tell you. I don't know what you're referring to. So that's the challenge that I have.
Well, I can try to research it, I guess. That's all I have. I can research it while you're allowing Inspect to speak his turn, I guess, if that's what you want to do.
No, I don't want to do that. I'm not going to take it up today because it's not in your motion. So if you want to file a new motion, I'll take a look at that. But I'm gonna deny without prejudice. So you can bring it back, but I'm going to deny without prejudice the motion to extend time to serve plaintiff. There's just, quite frankly, there's not enough for me to make a determination on that, nor a legal basis.
I've got RCW 4.16.170. Now that's saying the 90 days apparently.
RCW, what?
4.16.170.
Sir, I can't. I'm not going to grant it on that basis. I can't give you legal advice.
Sure. All right, my bad. I guess I didn't get that thing. I just used the the chat thing to go do some research for me, and apparently it doesn't get things right all the time.
I will tell you, in most lawyers' experience, ChatGPT rarely gets things right. It is be very cautious. I would urge you caution in that regard. Mr. Specht, I've been talking around you, but I'm not ignoring you, sir. Do you have anything you'd like me to know about the various motions that he's brought?
The process server had alleged that he had came various dates in December, and I think it started December 1st. Well, Sheila and I were over on vacation in Hawaii until we got home December 5th. I dropped her off at her house after 12:30, and he tried to serve that day, but she's upstairs and sleeping, And then after that, there was another date, and that time she had gone down to California. She has some she wants to get her hip replaced. But that's all in regards to Sheila, and they're saying that she was trying to avoid the service. But I do know that the plaintiff alleged, and it's true, that when I got served on the 5th, when I was home, he wanted me to take Sheila's. I knew I'm not the one responsible to serve it, so I just said she's not. I don't know her, which is a lie, but that's the way to get rid of him. I just wanted him out of my place. Yeah, and can we move forward on to my response to some of his allegations, or
Just briefly, but
we can?
I mean, we can, but it just needs to be brief because, quite frankly, I'm not inclined to grant it anyway. So, just briefly, what do you want me to know in response to his argument about deleting the affirmative defenses? Mr. Specht, what do you want me to know about the motion to delete affirmative defenses?
Oh, I'm opposed to him deleting that. Yeah, I mean, those things are under penalties of perjury, true statements that I've made.
I'm going to deny the motion to strike. I think there is lots and lots of factual disputes, but I can't, quite frankly, on an 86-page complaint, or amended complaint, I can't figure out. I reviewed it to try to figure out what affirmative defenses might apply or might not. I can't. It's going to be very difficult for the court, or let alone a jury, to try to figure out what is going on in this case. This is, for both of you, I can't give you legal advice, but please try to research the rules, try to do what you can to understand how to if you're not going to hire counsel here, to make sure that you're complying with the rules, make sure that your pleadings are proper, that you're doing proper service on each other. But I just cannot at this stage of the pleadings in this stage of the case determine if there is a basis by which to strike affirmative defenses. Yeah, anybody have any questions about that?
Yeah, would you like me to file a second amending complaint so I can try to streamline my 86 pages and cut it down?
Whatever you choose to do, sir. All I can tell you is I tried to wade through it and it was difficult.
Okay, I get the message. Thank you.
I'm not saying you have to even do anything on that. I'm just saying in the future, try to hone your pleadings to what you want the judge to know. Because it seems to me like this case, from what I read, and I'm not going to prejudice anything in the future, but it seems like there's plenty of personal animosity issues going on here. But I will tell you both, it is very difficult to wade through the volleying of back and forth here of accusations. So I just leave that as a cautionary tale for the future.
Okay, thank you.
Sir, do you have any questions?
Not questions, but kind of some refutes of what.
I don't need him. I'm ruling against him at this time.
Oh, okay. Sorry.
I'm ruling in your favor. I don't need to hear any more.
Thank you, Honor.
All right. I've reviewed all the pleadings. And those are my rulings. I'm going to deny without prejudice this issue of service, and I'm going to deny the motion to strike. They might be a time and a place in the future to be able to do that, but I can't do it right now.
Your Honor?
Yes.
Can I make a motion to dismiss this case?
You have to file that in writing, have it served upon him. He gets a chance to respond to it.
Yeah.
That's the process. The process applies equally to both of you.
Okay. Yeah.
All right. Thank you both. We're done today. Have a good day. There's 2 remaining
you.
individuals in the breakout room. Sir, you can go if you want.
Okay, I'm hiring a lawyer.
All right. I don't want to hear it because he's already left. Or we're done. Whatever you two do from now on.
This message has been transcribed. One moment while I notify the caller.
So we're done for today. Thank you both.
Okay.
Next, I'm going to call